All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Please be seated. Court will now call 04-18-411 CV Repsol Oil and Gas USA LLC et al. Versus Matrix Petroleum LLC et al. Announcements, please.
Ready for the state-owned entity.
Good morning.
Tom Phillips and Stephanie Conyar for Repsol, rest of the name. Yes, USA LLC.
Good morning, Mr. Phillips.
Sharon McCauley for the Matrix parties, Matrix, JAR, and TMRX. We are ready.
Very good. Good morning.
Good morning, Your Honor. Marcy Greer for OGE LLC.
Very good. Good morning. Good morning to all. The parties, I understand, have filed a joint motion agreeing to the splitting of argument, and we've also been apprised of any splitting of time. So I'll rely on your memories in that regard. You may approach the bench once it is your turn, and you are welcome to remove your mask or maintain it on. If it's on, just use your outdoor voice so the mic can pick you up. If at any time the court welcomes the advocates on our Zoom virtual platform, those that might not be here, and we welcome the parties here in person here at the 4th Court, downtown San Antonio. For those who are on our YouTube live stream, we may suffer some technical difficulties. Just be patient. The in-person argument will proceed, but a recording will be available should anyone want to hear or view it later. Let's see. With that, beginning with counsel for appellants, you may proceed.
Chief Justice, Associate Justices, may it please the court. My name is Joe Rohde. I represent the Statoil entities along with Eric Lipper in this matter. The Statoil entities appeal is basically ones involving judicial declarations. I want to address first what I think is the keystone issue in those judicial declarations, and that is the order of the trial court construing Section 8 of the joint operating agreement to require consent unanimity for the drilling of new wells. I'd like to put these remarks first into a context. Section 8 is a non-consent provision as regarded both in the industry and in the oil and gas jurisprudence of Texas. It governs what happens when a working interest partner determines not to consent to a proposed well. It is an allocation of risk provision, which has been a part of the oil and gas business since at least the early 1950s. We have cited to the court in our brief a learned treatise by Mr. Eugene Kuntz, or Professor Kuntz, in which he traces the history of the beginnings of the AAPL form JOAs beginning in that era. And what it demonstrates is that in the early 1950s, oil companies attempted to come together to bring the forms of JOAs in a consistent context so that there would be some consistency throughout the industry in the use of JOAs. The JOAs that we have included in the record include all of those which began with the 1956 JOA, which according to Professor Kuntz was the product of the getting together of the operators and the AAPL, which put together in 1954 a form which was ultimately approved in 1956. As represented by the 1956 APL form and every form since then, there is a consistent reading of the non-consent provision to allow the proposer of the well to drill the well, notwithstanding the lack of consent of one or more of the working interest owners. This I represent to the court is a public policy matter, because the Supreme Court in the Carrizo oil and gas case held that Texas has a strong public policy not to hinder the exploration and development of oil and gas. And that has been a consistent history since the 1950s. As I've said, Section 8 is a risk allocation provision. The oil and gas development in the 1950s, as today, is a risk-taking business. The purpose in the 1950s was the same as it is today, for one working interest owner to accept the risk when another owner or owners choose not to consent to the well. The second element of the context is that the 1954 JOA expressed the particular JOA involved in this case, expressed the purpose of the joint transaction with their announced intent. In the preamble and in Section 4, they state that the purpose of the JOA was, quote, to explore, develop, and operate the Cook Ranch minerals for the production of oil and gas. They had 5,300 plus acres to explore, develop, and operate. The question here before the court is whether the plain meaning of Section 8, construed as a whole in the light of the purpose of the agreement, may be construed to allow one partner to veto further development. The trial court, with due respect, has taken one phrase out of grammatical context to the exclusion of 3/4 of Section 8 to declare that no new well may be drilled without the unanimous consent of all of the working interest partners. In the 1950s, there were 2. Today, there are 6. The most important phrase in Section 8 is not the phrase, no well shall be drilled on the leased acreage unless all parties consent, which was the one which the trial court emphasized. The most important phrase is found 10 lines down from that, which is, in the event the parties hereto cannot agree upon the drilling of any well. This phrase and all that follows it in Section 8 of the JOA was made meaningless by the ruling of the trial court. Section 8 was ignored by Matrix and OGE in their briefings. They tried their best to eliminate that remainder of Section 8 as affecting the interest of the parties. They tried to shut it off to relate to the reasonable development requirement or exclusion, excuse me. but that was not grammatical.
If I may ask you,
Yes, ma'am.
since you point the court's attention to the sentence 10 lines down, beginning with in the event the parties cannot agree.
What I'm sorry, I can't understand the court with the mask. Sorry.
Beginning with the phrase in the event the parties hereto cannot agree, how far down into that section do you think our attention should end to make the point you wish to make?
All the way to the end of section 8, Your Honor.
Just to be clear.
The rest of the provision, in fact, looking at it in a very undramatic but practical context, the trial court construed 9 lines of section 8, leaving 29 lines unconstrued, when those 29 lines are the essence of what section 8 is about. The grammatical predicate for the precedence of the cannot agree or the non-consent provision is the phrase except as is otherwise provided in this section 8. That's the beginning phrase of section 8. And what it means is there are exceptions to unanimity to be found in section 8. We understand, and nobody disagrees, that the exceptions for drainage and the exceptions for reasonable development are evident. And those were included in the first 9 lines of section 8. But there's no argument here about either drainage or reasonable development. The grammatical reading of section 8, beginning with that phrase, except as is otherwise provided, establishes that there are provisions which provide otherwise than requiring unanimity for drilling of wells. And I would say, just as an aside, that the first two exceptions, reasonable development and prevention of drainage, are duties which are owed to lessors. They are not operational provisions relating to what the working interest owners do on the ground or how they develop the property between themselves. But the cannot agree non-consent provisions also provide otherwise than for unanimity. The language of section 8 grammatically gives effect to all of the exceptions to consent unanimity. And the failure to agree to drill a well is one of those exceptions. I return again to one of the purposes of the non-consent provision is to allocate risk. You don't have an allocation of risk by the determination of one of the owners to drill a well unless you have the right to drill the well. And so the remainder of section 8 deals with what happens when one owner, typically the operator, decides to drill a well and one or more of the non-operating working interest owners determines not to consent to that well. Why have that provision at all if the unanimity provision controls? It does make sense. You don't have those provisions calling for what happens when one owner disagrees if you have consent unanimity. The cannot agree language, which is the non-consent language, contemplates the potential lack of unanimity. It is a direct contradiction to the language relied on by the trial court and relied on by Matrix and OG in this case to claim that consent unanimity exists, but is required.
Mr. Rhodey, I have a question for you, sir. Earlier you had, can you hear me okay?
Not very well, Your Honor.
Okay.
Thank you.
Earlier, you had stated that we should construe the language within this provision and look to the purpose of the agreement. Is the purpose of the agreement one and the same as the intent of the parties here?
Yes, it is. It is to operate, it is to explore, develop, and operate the leased premises. If you're going to explore, develop, and operate 5,300 acres, you need to have the ability to drill wells, more than one. And if you give full effect to the right to veto the second and other wells, then you defeat the purpose of the agreement, which is to fully develop 5,300 acres.
And is it your position, if I'm understanding correctly, and please correct me if I'm not understanding you correctly, is it your position that historically these agreements represent what you're saying, and there was no bargaining, for instance, with the proposed language with that ultimately arrived to this exact provision within the agreement?
I don't know that there is anything in the record about the bargaining, Your Honor. This lease, this JOA was negotiated and completed in 1954, and there is no evidence from either of the participants in 1954 that would deal with the question of how they may have negotiated.
Okay.
All we can do is look at the fact that one of the two had a 75% interest and the other had a 25% interest. And with those facts in hand, you know that one of those two at least wants to have a complete development of the 5,300 acres. If you give effect to the veto, the 25% owner could defeat any further development after the first well, taking it literally. So that's one of the facts that would be discernible from the instrument itself.
Thank you, Mr. Rhodey.
As I was saying, the language that we're talking about, beginning with the non-consent provision, it contemplates the drilling of a well without the participation of the unwilling owner. And it contemplates a notice of intent to drill a proposed well. It contemplates a timetable for response. It contemplates an opportunity for the unwilling working interest owner to reconsider his refusal at first to participate. There's a 30-day window for negotiations if the parties decide to negotiate whether they want to drill that particular well. But it also provides for the ability of the working interest partner to go ahead and drill the well. And that is the essence of what the non-consent provision is.
Council, I'll give you another minute to close
One minute.
with your remark.
Thank you, Your Honor. I want to go to the second part of what I wanted to cover this morning, and that is the construction of the term assignments. The term assignments, Your Honor, is kind of an unusual situation relating to oil and gas development. But in this case, the question is whether the term assignments supersede the JOA to the extent of any conflicts. And we submit that the term assignments do, particularly because the term assignments contain no non-consent provisions. It contains a commitment to drill 3 wells per year. There is no opportunity to opt out, no opportunity to not participate. And in that contradiction, we submit that the term assignment commitment to drill 3 wells supersedes the Section 8 limitations on the drilling of the well, to the point where the participants, which would have been Matrix and JAR and Talisman and Statoil, were obligated to drill 3 wells each year. And that, may it please the court, has considerable effect on the question of what the declarations of the court the declarations of the court that need to be reviewed by this court and construed differently as we have submitted in our briefs.
Mr. Rhodey, I do have a question.
Yes.
If we were to agree with you, what would our judgment provide with regard to these declarations?
I understand. You would restate the judicial declaration. You would restate that Section 8 provides for a well to be drilled without the consent of an owner that refuses to participate, refuses to give his consent. You would read it grammatically and say that that opportunity exists for the proposing well owner. We have included in our brief, Your Honor, and in our appendix, a list of issues which depend upon the result of that non-consent provision determination. But you would also, in your opinion, restate the other judicial declarations that we have contended were in error or that should have been entered by the court pursuant to Statoil's request for declarations. So what I perceive coming from the court is a restatement of the judicial declarations, particularly because they are forward-looking. And as the court may understand, Statoil, during the course of its operatorship, drilled 12 wells, only 3 of which were covered by the judgment. Since it drilled 12 wells, all of the judicial declarations which were entered by the trial court affect all 12 wells because they were forward-looking. I would expect that the court could not determine what the monetary effect of those declarations were, but what the particular effect is in a forward-looking basis to make certain that the law is correctly stated in the judicial declarations.
Thank you, counsel. Any questions, Justice Chapman?
No, thank you.
You'll have rebuttal time. Thank you, counsel.
My time is up. Thank you, Your Honor.
May it please this honorable court. I would like principally to address the elephant in the charge, that is the $79 million missing volumes award. There are many reasons why this award cannot stand. I'm going to refer to this bench book through the course of my argument, and so I'll give you tabs that you can turn to if you wish. And the first one is tab E. We're in their briefs to this court. Both appellees concede that to recover for missing volumes, they must first show that at least some of the production on the Cook Ranch was actually diverted to the Hinkle and Reed leases. And so the question is, have they shown that? There's no direct evidence of it, only circumstantial evidence. The principal circumstantial evidence is from the testimony of David Reeves, who outlines in some detail how reports to the Railroad Commission on the Hinkle and Reeves leases were first sent in seriatim with a bunch of smaller numbers and then several years corrected to a bigger number. He says some of the additional volumes from that bigger number must have come from the Cook Ranch lease that the appellees have an interest in. And that's really it. All the other things that they point to in their briefing as being some circumstantial evidence of this theft are either claims that relate to another part of their case for which they presented proof, carried the burden, won a jury verdict or lost a jury verdict, but at any rate are not on appeal here, or else they're statements that are belied, one statement belied by the undisputed proof in the record. So there's no circumstantial evidence. But even if you thought this was some meager circumstantial evidence of a theft, it's so meager that under the Supreme Court City of Keller test, you must look at the circumstantial evidence presented by the appellant and decide that there is a stronger inference in favor of the misallocation presumption than the inference that this was just a simple mistake.
Mr. Phillips, though, can't we, I mean, we have plenty of cases throughout our case law that affirm judgments that are based solely on circumstantial evidence.
Absolutely.
We talked about this as a theft, and good thieves don't leave lots of fingerprints, right? So how do we reconcile the fact that your client had all of the information, and it appears that in some form or fashion during the discovery process, refused to turn some of this information over? That would have led to possibly the discovery of direct.
I don't know anything we failed to turn over. We said the Railroad Commission reports are a matter of public record. You can go get them. We turned over Plaintiff's Exhibit 979 is 2 volumes in the reporter's record. It's all of the initial metering report, and it's all the Railroad Commission reports metering. We asked them, why did you not ask for the Hinkle and Reed metering reports so that you could see if there was actually less produced there than what we ultimately reported to the Railroad Commission? Our Railroad Commission corrected reports, as we show in our reply brief, and there's a motion to strike that's pending. Those corrected numbers are consistent with the initial numbers that we sent into the state comptroller for severance tax purposes. The circumstances, we think, are very strong that there's no theft here. For instance, the Hinkle and Reed wells were classified as oil wells. And under the Railroad Commission, tab H, I think it is. It's hard to read, but statewide rule 4, a well's gotta be an oil well or gas well. And gas wells, you report on each list, you report wells individually. Whereas on oil well, you aggregate all the wells on oil lease and report it as one big number. There's a very strong inference here, given that the 2 oil wells were initially reported like, the 2 oil leases were initially reported like gas leases and later corrected. For this scheme to have worked, this theft that you're asked to say that there's circumstantial evidence for, Repsol would have had to go into the Cook Ranch leases to the lease, which had at one point or another 17 wells on it, had about 14 at this time, I think, and change the meters, which were manufactured by a third party, on some or all of those wells, so that they showed a much lower number than was actually being produced. And for the scheme to really work, they would have had to go change meters on the Hinkle and Reed as well. Then they did all this to have a larger number on the Hinkle and Reed than what was actually produced. And they should have turned in the big number to the Railroad Commission, the same as they did to the comptroller for payment of severance taxes. The whole inference that there was a theft of property here is it would be so hard to do it and so convoluted, and it was carried out in such a crazy way. I mean, why would you turn in 4 or 5 different numbers within minutes of each other if you only wanted the last number to be the one that people thought had been produced from that, and you were off stealing product from another lease? So we think under City of Keller, where you have to balance the circumstances from that both sides put on in evidence and overcome the equal inference rule to say that the circumstances here preponderate in favor of there being a theft, you just end up with no evidence. Even if you think there's some inference, and even if you think this was properly pled and disclosed, and I want to get to that before I finish, as a matter of law, the proof that the appellees brought for this loss does not support the damage award. The only proof of this number, nearly $79 million, came from David Reeves, who created and vouched for Plaintiff's Exhibit 1295, which is tab J.
Counsel, did your trial counsel object to plaintiff's 1295?
Yes, we did. Yes.
Okay, can you Do you have a,
14 reporters record, let's say 306. It's in the brief. That may be a page or two off. As soon as it was offered, we asked to approach the bench.
very good.
We
Thank you.
approached the bench. Okay. When you look at this,
Memory's better than mine.
well, I've read this several times and I could be wrong. If you look at tab K of our bench book, you will see that Reeves repeatedly said all that this 1295 shows is the loss that the appellees, actually, he was just testifying about Matrix, could have suffered from the additional product on the Hinkle and Reed that was reflected in the amended Railroad Commission report. That is product from 2 leases for 2 years. He also testified that Matrix had approximately a 24% interest on the Cook Ranch, and that 1/6 of that was owned by OGE, and that he didn't testify this, but the lawyer kept representing, and there were documents, that there were approximately 400,000 added barrels reported to the Railroad Commission, added barrels of liquid during those 2 years. Well, do the math, 400,000 barrels, $79 million, 28% interest in those 400,000 barrels. It means that oil's coming in at about $700 a barrel. And if you look at 1295, it's got product on all 5 leases for all 5 years. It simply doesn't correlate to what they told the jury they were seeking and what was being proved by 1295. In fact, the real killer and what got us into this is that the chart is so convoluted, 1295, that the parties in their briefs to this court can't agree on what it shows. And if you look at tab N, you'll see Matrix justifications for the number, OGE's justification for the number, and they're entirely different. So under the Point West and Downing cases that are on page 35 of our opening brief, even if you thought this had been disclosed, even if you think the circumstances preponderate in favor of the plaintiffs, you can't affirm this number. You can't figure out any way to remit it. It has to be remanded for a new trial.
Before we move on from that point, I'd like you to respond to your opposing counsel's argument that even taking the individual standalone filings to the Railroad Commission that were subsequently corrected, that even those don't support, I mean, those don't ultimately tie in with the data that Talisman subsequently provided. Is that correct?
There were mistakes, as you know. Repsol bought Talisman in 2016, and there were several hundred corrections filed with the Railroad Commission. Some of these favored the Cook Ranch. They ended up with close to 20,000 more barrels than they initially had. But it's still no evidence of any theft. The fact that you're sloppy and make 2 mistakes on the same well to the Railroad Commission does not show there's any theft. You know, payments weren't made off of this number to the Railroad Commission. It's just a total disconnect that what's reported to the commission in any way shows a theft.
Mr.
So,
Phillips, might I interrupt you? The mistakes, can you please explain and clarify what those mistakes were? Was it earlier you had said that they were reported as gas wells or oil wells, and it should have been the reverse. Is that the mistake that you're referring to, or was it a reporting in the sense of quantity and production in terms of where they allocated?
the missing volumes, which I focus on, are what we think our circumstantial inference is the treating an oil well as if it were a gas well. That is, it's these reports on the Hinkle and Reed, big changes that were made for those 2 leases for the years 2013 and 2014. But what they mention in their brief is that there were subsequent changes on other leases, including the Cook Ranch, particularly after Repsol took over, changed an accounting system, and went through all the numbers again. So there's really 2 different things going on. And my answer is neither of those in any way show a theft of property from the Cook Ranch over to the Hinkle and Reed.
And are you using theft and commingling as one of the same?
No, they're not the same. And let me go to commingling if I can. Because the appellees claim that they win because ultimately all this product was put into a central delivery point, a CDP, and that shifts the burden to us to prove once again how much belongs to everybody. But all of these wells were metered at the wellhead before they left the ranch, and under Humble Oil and West and almost every other commingling case in Texas or elsewhere.
You make
If
it
it's-
sound like there are a lot of commingling cases.
There's about 8. It's not a big, it might be a big deal after this case. It's not a big deal so far. But at any rate, all those cases are circumstances where there is no initial metering. There's nothing for you to attack. It's just the product's all there. And you say, well, some of it's yours. We think it'd be this much. And the courts force the person who has commingled to prove that. Let me quote a little from the Lindemann case, tab P. The jury would have had, which rejected commingling and said the jury would have had to believe that either the production records for the DD Strange had been falsified or that appellant intentionally misset the separator after pumping. This conclusion would require too much speculation on the jury's part. But even if you think this commingling occurred here and somehow that shifted a burden, it's important to remember that none of these missing volume questions actually shifted the burden. You look at 1B19, 2B19, 3B19, 4B19, 6B, 7B19. They all put the burden on the plaintiff, now the appellees, to show the loss they had suffered. Now, I want to turn in the remaining minute and a half to the other reason why this number has to be vacated, and that part of the judgment rendered. And that's that we didn't have fair notice of this claim. The pleadings don't give fair notice because all of the language that's being pointed out to you as a pleading of this claim are applicable to other narrower claims. And as tab Q shows, Boz v. Smith, principally from the Supreme Court, when a pleader provides both general and specific allegations, the specific controls. The disclosures don't provide notice of this either. None of the disclosures, none of the pleadings ever mention the term missing volumes. And they never say that product that was actually from the Cook Ranch was instead maliciously misallocated to the Hinkle and Reed. Appellees, in fact, are on the horns of a dilemma if you look at tab R. They made their final disclosures on June 26th and June 28th. They either knew of this claim at that time, and thus they had a duty to supplement either by then or supplement later. But on June 20 and on June 29th, David Reeves testified that he had, quote, no other specific claims in this lawsuit for which he anticipated providing expertise in terms of damage calculations or other quantification. So they either knew then and they were hiding it, or they didn't know and they didn't subsequently disclose. But more than that, they didn't know, and yet they say that Repsol should have read what they did, what they put in their disclosures, and known something that they didn't know about. Finally, if I may proceed just with a closing, this was not tried by consent. There was a timely objection, Justice Watkins, and appellees had and failed to carry their burden to show unfair surprise or unfair prejudice from this disclosure.
I have a question for you, Counsel.
Certainly.
Certainly, I think the resolution of the of your legal and factual sufficiently arguments are going to be fact intensive, and so we'll
They
review
are.
that accordingly. Is it going to will it require a judicial notice of those filings, the RRC reports to?
For the judicial notice of our filings with the comptroller or the Railroad Commission?
Yeah, to judicially notice the RRC reports that are not in the record.
I think plaintiff's 979 has everything on the Railroad Commission that you need. The state comptroller's records, which we think bolster, we don't have to show that they're true, the numbers in the state comptroller's records. What they show is our state of mind at the time we reported them. We think that clearly under the way the Supreme Court's been going on judicial notice is sufficient. I mean, it shows what we thought at the time, 1 month after production, that we sent in these numbers to pay severance tax on. And it's good enough for that point. The Brazos River Authority case that's just come out this year let in testimony given to a legislative hearing on judicial notice on appeal on the grounds that not what the witnesses were saying were true, but that they thought it was important and therefore it showed it was a matter of public concern. But if I'm wrong about that, we'll correct it this afternoon. But I believe everything you need from the Railroad Commission, from those reports, is in the record, if you want to read through 2 volumes.
Thank you, counsel. Any questions?
No, thank you.
Thank you.
Appreciate it. You may proceed.
May it please the court. Your honors, my name is Sharon McCauley, and as I said before, I represent the matrix parties. In my time before the court, I will principally respond to the argument that you just heard about the missing volumes. It's actually the Humble Oil argument, and you didn't hear a whole lot about Humble Oil, so I'll tell you a little bit more about Humble Oil in my time before the court. My colleague's time, Marcy Hogan Greer's time, she is going to be discussing the contract interpretation, and because Statoil did not address your jurisdiction, she's also going to be addressing the motion to dismiss against Statoil, who no longer has any interest in this oil and gas field, which deprives it of any jurisdiction to complain about the declarations. So
I'm glad you are, because I'd like to see what claim urged by matrix fits nearly into the Humble framework.
you're ready for me to begin with the Humble Oil case. I want to, because counsel did not tell you what the Humble Oil case stands for, what it does. And as the court has noticed, there's really not that many cases that talk about the Humble Oil case. But one thing we know for sure is that in not one of the cases that follow Humble Oil from 1974 in the almost 50 years, not one of them says this doctrine simply does not apply. It's actually known as the commingling rule. And it does apply when there is commingling of product. And that's exactly what we have in this case. The court set forth a three-part test, the shifting of burden. First, we demonstrate we have an interest in the commingled product. Then, having done that, the burden shifts to the commingler to demonstrate that they can adequately allocate. And finally, if they don't meet that burden, then the interest of the party claiming commingling that was wrongful because of an inability to allocate then gets a percentage, a net revenue interest here in the whole.
But counsel, doesn't your argument presume that somehow the commingling was wrongful at its inception? And here, the parties have agreed to commingle through the CDP.
My argument does not presume that, Judge, and it's a great question because it's been obfuscated by the other side, and there's a couple of decisions that are a little bit unclear on the way they present it. I would even rely upon the Lindemann case that counsel mentioned because I think it's got one of the clearest ways of saying it, even though I think Humble Oil is pretty clear about it too. Here's what it means. It is okay in the state of Texas. The Railroad Commission allows and permits for commingling. So commingling per se is not wrongful. We know that. But what Lindemann says specifically and what Humble Oil says implicitly is that it becomes wrongful when you, the commingler, do not have an ability to account for the aliquot share of the commingled product. So once, and really it's, as a mother, I think of it as we don't reward bad behavior. It may not be wrongful behavior in the sense that we have scienter. It's not that kind of wrongful, but it becomes wrongful because there is a duty to account that attaches when you commingle. And if you render it absolutely impossible for the person whose product you're commingled to prove that you didn't pay them your appropriate interest on it, then your bad behavior is rewarded. That's the reason for that shift of the burden. And what Talisman is trying to do is conflate those two and say, if they are able to prove, if they're able to point you to metering, if they're able to come up with some evidence to prove to you that they could account, then the doctrine simply does not apply. But Humble Oil tells us that's not the way it works. And even on the facts of Humble Oil, we know that it's not the way it works. Because if the court has glanced at that opinion, you'll know there's only about this much of it that's really even dedicated to this question of commingling. Most of the case and most of the cases that talk about the Humble Oil case talk about the first type of relief that the Wests wanted. They wanted an injunction to forbid the injection of oil into that storage tank. They didn't want their stuff commingled at all. And the court rejected that request for an injunction and requested Humble Oil in that case, their suggestion that maybe they could go ahead and pay just the portion of the production that was owing to the West. In other words, they knew exactly how much was owing to the West before they ever put the oil and gas into the storage tank, just the way Talisman's telling you they can do it here. But the Humble Oil case said, no, we really don't care. We believe the Railroad Commission when they tell us it's a valuable thing to commingle, because in the Humble Oil case, there was going to be more oil and gas produced if they did the injection and the commingling. So the Railroad Commission had already blessed the commingling, and there was a capacity to determine what amount was going into that storage tank. And Humble Oil said, we don't care. They have an interest in the commingled product, and therefore the burden is going to shift to Humble Oil to show an accounting. That's step 2, and it belongs in their column. So once we show an interest in the commingled product, they're the ones that have to account. They don't dodge the whole analysis just because they believe they can account. And before I go to step 1, I really want to address that too, because counsel spent a great deal of time telling you about the evidence of how, it can't be. I mean, the Railroad Commission reports can't possibly mean what they say. It's a scheme that has no meaning. Actually, it's exactly what the jury was looking at, not just on the day they heard about the missing volumes, when Mr. Reeves started testifying about it in volume 14 before they objected in 15. I'll tell you about that in a minute. But when the jury was listening on the other damage awards, they were listening to accounting and allocation shenanigans. That's the nicest word I can actually use, because for 4 weeks, what they heard was that the Reeves were trying to get information about, this doesn't look right. What you're paying us, it does not look right. So maybe we should get an audit. Let's do an audit. And all the while, Talisman's stiff-arming them, not giving them what they need, and resisting an audit, basically tooling them around on the audit. And that caused the Reeves to file a lawsuit. And what happened? They took discovery and found out all of it was deliberate, and that all of the emails in the record are going to show you that Talisman was deliberately not providing them with information for them to ask questions. They knew their allocation methodology wouldn't work. They knew their numbers were wrong. They knew, for purposes of this argument, they could not even back into an audit. They could not justify these numbers. There's no way they could get back to that number. And indeed, when our expert, Mr. Spilker, went and visited with their in-house accounting people and said, help me understand this, they revealed to him that they had destroyed records. And so there are at least 3 witnesses that the matrix parties brought to show the jury it could not be reconciled. There's no way they could get back to that number. So when Talisman tells you they put up their internal accounting person to say, we paid on this, we paid on this, we really don't even pay on railroad records, you just don't understand, it's a glitch. That provided the jury with 2 choices. They could either believe this was a glitch, the way Ms. Bugamelli said, without having even undertaken to review the records herself. It's a glitch, that's serial reporting. Or they could believe that this was one more example of Talisman cheating, and yet this time they got caught because they amended those reports, added 800% of production, and allocated it all to 2 of the leases that were commingled at the CDP, 2 that were not coincidentally owned entirely by Talisman. So when I say that we can prove that the commingled product included our stuff, there's 2 ways we can do it. First of all, Humble Oil doesn't require me to show an interest in the missing volumes, okay? Because that's part of the whole. These are amended reports. It just adds on to the 2013 and 14 production.
Let's talk about what Humble provides. Under Humble,
Chief, if I might interrupt you just for 1 second. Mr. Phillips, would you mind putting your mask back on? Thank you. I appreciate that very much. Excuse me. Thank you. You had such great momentum. I didn't want to interrupt.
That's all
you,
right.
so
I'll
I
gin it
didn't
back up, Judge. Thank you so much. I think Judge had a question. Did you?
So under Humble, as I understand, the confusion of goods should result in the forfeiture of the commingling party's exclusive rights to the oil and gas that the non-commingling party would otherwise does not have an interest in. And from what I understand, Matrix argues that the amended RRC reports filed by Talisman constituted a quote net revenue of $278 million produced through the CDP. You argue that the reports reflect an increase of the oil and gas run through the CDP that Talisman had no basis to attribute to any specific lease. For example, not to Hinkle, not to Reed lease. Under Humble, though, the result, would it not be, that Matrix should be paid as if the oil and gas were produced from Cook Ranch?
I disagree with you, Judge, and I don't think the testimony supported that. I believe Mr. Reeves in volume 4.
Well, directing your attention to what Humble might provide. And then I note also that Humble, I don't believe, involved a case where there was a dispute in the piece of the pie, as it were, unlike here. So what impact does that have on our analysis?
If I can return to the previous question, and if I understand it, I think I would say that because the question was presented to the jury in terms of the missing volumes, and it was presented to them without objection, then the testimony that mirrored the net revenue interest of the working interest owners in those missing volumes is the appropriate measure, not only under the jury's question, but under prevailing law, because that's what the jury was asked to find.
Well, if we stick to your calculations matrix, as it were, the damages model that would support the $67 million award, that it should be paid by some historic percentage of oil and gas revenue on the reported increase of production. Matrix's brief doesn't explain this calculation in its brief well, and OGE as well provides no guidance on that. So what is if the historic percentage, which I understand which was presented, was 24.31%. Where in the trial record is that contained to support any jury finding in that regard?
I do not believe that was what Mr. Reeves' testimony was to support his methodology for calculating the net revenue interest.
I'm not making an assumption that it came from anybody's testimony. I'm asking you where in the record would support this historic percentage to support the jury award of $278 million.
I think the historic percentage that can be gleaned from the record was the thing that allowed Mr. Reeves to suspect that Talisman was cheating with the increased production. Under Humble Oil, we then look to the total size of the pie, and we say, can you allocate our portion? And because they did not even ask the jury a question about whether they could, but the jury in 6A found they could not, we then went to step 3, and the calculations that Mr. Reeves was conducting, given suspicions by historic data, was he took the net revenue interest that was generated by the additional volumes and then calculated Matrix's net revenue interest in that production as generated through the CDP. So he didn't take a lease interest. He went through the CDP at the tailgate which is the way it should be calculated for the total, that gives credit to the costs. It's a net revenue, if that makes sense. So his calculations were strictly on the entire pie, our net revenue interest, because we had no ability under the Humble Oil case. That's the whole point. We had no ability to calculate. We know that 100% of the new volumes did not belong to Hinkle and Reed, not only because historically we know it's spread across, but also because the new volumes took some of our piece of the pie. That's what Mr. Reeves testified to.
So
And
if I may, putting the calculation aside again, and you resort to Humble being some guidance, but again, I don't believe in Humble that there was any dispute about the size of the commingled mixture, about the size of the pie. So what you're suggesting is that, I mean, what? Because again, that's not direction that was provided under the Humble framework.
I think that's probably true because it was remanded for the calculation of the entire piece of the pie. So in Humble, there was an acceptance that they were going to commingle, as the Railroad Commission said they would, in contrast to Lindemann.
Stop you there,
right.
But, and I understand that Humble was remanded, but when it was remanded based on uncontroverted testimony of the commingling parties experts as to the calculations of the volume of the native gas, unlike in this case. So again, how I understand your argument that you're wanting to point the court to Humble to provide some direction. I'm simply pointing that this matter before this court may not be easily resolved, since Humble did not involve uncontroverted testimony, even on remand, unlike here where there's clearly a dispute about the calculations and methodology.
I'm so sorry, Judge.
Any other guidance the court can.
I'm struggling because I'm not sure that I'm even really understanding the question, Judge, and I see that my time is up, but this is really critical to me, that there was no dispute in Humble on remand. First of all, let me back up to step 2. At step 2, Humble Oil attempted to establish what the interest would be, the interest in the commingled product. Remember, in the beginning, they knew what the interest was of the Wests, but once it was commingled, there was not, at least in the original case, there was not agreement about what the commingled amount would be. So the burden shifted to Humble Oil to demonstrate that substantial certainty of what the West share was. They tried to do that, but they were using averages. So the Texas Supreme Court remanded it and said, you're going to have to do a better job proving that now that we've given you the burden shifting. So the parties entered into stipulations below about the size of the pies. So the dispute about the size of the pie made sense in that case. I think the only real wrinkle we have in this case is because there was an original pie, the 2013-14 reports, and then it was added to the pie. The pie was made bigger. That doesn't mean we didn't have an interest in the pie. It means that they're trying to point to the new stuff and say, well, you've got to prove that you had an interest in that piece of the pie. That's impossible to do, as Humble Oil is sort of telling you. That would be an allocation shifted back to us. You got to show us what part of the whole pie that you have a percentage of. But instead, the burden is supposed to be on Talisman. They did not ask for a question that they had proven it. And even if they had, the jury had the prerogative to reject all of it when given the question about missing volumes. It was already presumed. Talisman just has waived all of this by not submitting a question to the jury to give the jury an opportunity to find that they had allocated with substantial certainty. But even if you don't think that that was subsumed within this missing volumes, the testimony was disputed throughout this trial about whether they had any capacity to go back and allocate. Their own internal emails say they can't do it. And so the jury was free to reject. And that's really what this case is all about. A jury verdict under assault and the substitution of this court's view, adding new records to the the appellate record as if the jury could not have rejected those, and you have to consider them. To say that the jury could not have rejected Bugamelli's testimony, that even though David Reeves convinced Talisman that he was right about the analyses through the informal meetings and the audit, he convinced them, but somehow this court should not credit his testimony as being some evidence that they commingled and could not allocate something that belonged to us. So we are asking the court to affirm the finding of net revenue interest on the missing volumes that was unequivocally tried by consent by these parties when the entire defense case, expert, fact witness, all testified on missing volumes for Talisman. And I've neglected to give the court that citation, Judge. 15 RR 22 to 27 is where Exhibit 1295 was moved into evidence. The only objection was a competency. Mr. Reeves then testified about his competency, and the judge overruled that objection, not brought forward on appeal. Thank you for your time.
Before you leave the podium, counsel,
Yeah, sure.
I do have one question, maybe a couple. I just want to make sure that I'm understanding what you're saying and kind of rectify what Mr. Phillips had said as well. Is it undisputed that there was commingling? Does the record show that there was commingling?
Yes, Judge, yes to both questions. Yes, there's commingling, and it is undisputed that it was commingling. There was a railroad permit to do it. They didn't really follow those rules, but it's undisputed in this record.
Okay, and so it was no surprise that commingling had occurred.
That's correct. Stark contrast to Lindemann. Lindemann had no commingling by the Railroad Commission.
Okay, and were measurements taken before the commingling occurred and after the commingling occurred?
Talisman alleges that measurements were taken before the commingling occurred, but the substantial record evidence shows that their meters were broken for at least 8 months. And so the jury was entitled to disbelieve that they could adequately meter and show on step 2 that they could meet their burden to allocate. But the other thing is, as I said, Humble Oil makes no provision for not applying in the circumstance where you can get a measurement prior to commingling. If there's commingling and we have an interest in the commingled product, the burden moves to the next step, to Talisman. Did that answer the court's question
Absolutely
about metering?
I appreciate the clarification. Thank you.
Thank you, Your Honors.
Good morning, and may it please the court. I'm going to address the contract interpretation issues as they pertain to the 1954 Joint Operating Agreement, particularly emphasizing Section 8, which is the key. I agree with Mr. Rohde, that is the key to this agreement, and it's super important. We start in analyzing that provision, as we do with any Texas contract, with discerning the intent of the parties by looking to the words that they use to memorialize their agreement. Here we've got a 1954 joint operating agreement between two parties. Paul Kaiser, who was the majority owner, he contributed 75% of the leases to the venture, and he was also the operator under the terms of the JOA. We also have Plymouth Oil Company, which was a minority interest owner, but it contributed 25% of the leases. So it too is in an unusual position. This is not a standard JOA. This was something that was unusual to these parties. We didn't have Mr. Kaiser or Mr. Halloran, the president of Plymouth Oil, to testify at trial. But we don't need them to determine what they intended. We have their agreement. And I think it's important for the court to recall that this agreement has never been amended and that all the parties in this room took their interests subject to this agreement as written in 1954. So we go back to the words of the agreement to see what it says. And Section 8 of this agreement is neither ambiguous nor obscure. It says exactly, it means exactly what it says. No well shall be drilled on the leased acreage in search of oil and gas unless all parties hereto consent to the drilling of the well. That is the general rule. In reviewing this writing, the entire JOA as a whole, which is important, we've been accused of, and the judge below has been accused of cherry picking just that first provision. We don't. You do need to understand that provision in context. And there are three things that we know about this agreement from the writing itself. We know that Mr. Kaiser and Mr. Halloran were sophisticated in matters of oil and gas. We know that they carefully negotiated this JOA. It's not a cookie cutter type agreement here. They have thought about the implications of each thing that happens, and they've treated them differently in different provisions of the JOA. The third thing we know is that these two parties placed a premium on consensus and transparency. Those were very important to them. And I think part of that shows the negotiating leverage that Plymouth had. Even though it was a minority interest owner, it was contributing leases, and it was also a very large percentage minority interest, 25%. And it negotiated its way into having some protections under this agreement. Section 8 is a good example of it. Going back to the premium on consensus and transparency, they were to share all records. That didn't happen in this case. They were to share information. They were to freely communicate, and they were supposed to have consensus on things that were important. There are 6 provisions of this agreement that require unanimity, that require all parties to consent. They are Section 5 for expenditures over $2,500, Section 11 to abandon a well, Section 12 to surrender leases, Section 18 to sell or mortgage interests in either leases or property equipment, and 22 to terminate the JOA. And then, of course, Section 8 that we're talking about. And in addition to the fact that Plymouth was a unique minority owner with leverage in this situation, Kaiser was both the majority owner and operator. So that placed it in an unusual position with a potential conflict of interest. And I would recommend to the court, if you want a clear roadmap as to how this provision works, I think Judge Wilson provided it in the very early stages of the case. In the second supplemental clerk's record, pages 1 to I think 9 or 10, is his order on the TRO. And that, I wish we had put it in our appendix, because going back and reading it, it all makes sense how he construes the agreement. And that was at the very get-go of this case. He got it from the beginning. And he said several things that are important. He said, he noted the conflict of interest that Kaiser had and the reason why Plymouth would have a need to protect itself so that it didn't have to consent to every well. It had the right not to consent. The unanimity gave it the right to prevent a well from being drilled if it was not going to be economical or if it had ramifications that on other producing wells. Like in this case, for example, there was a concern that the wells proposed by Talisman were going to steal or take volume away from other producing wells. Very legitimate concern. This was all stated in the documents in the trial, like their Statoil Exhibit 27. They explained they weren't just not consenting to veto, they had legitimate concerns about whether these wells will be producing, concerns that turned out to be well-founded. The words "no well shall be drilled on the leased acreage unless all parties consent" is emphatic and binding. It's not aspirational, as Talisman and Statoil contend. It has a requirement that means what it says. The unanimity is the general rule, and then there are 4 exceptions. And those exceptions, they're not applicable here. We're not fighting about whether or not one of the exceptions applied, but I just want to line them out so you understand the context. There's the Section 7 exceptions. There are 2 instances where Talisman could have drilled a well without consent. The initial production, which was long since passed by this point, but it also could have drilled a well more than 2 miles away from a producing well, a known producing well. And it didn't need consent to do that because that was in Section 7. Section 7 had its own balloting process, not covered by Section 8. That's why there's a carve out for Section 7. The other 2, as Mr. Rohde pointed out, are in Section 8 itself. They are if wells are needed for reasonable development or to protect against drainage. In those situations, they don't need consent either. And so you have under Section 8, consent wells and non-consent wells. The consent wells are where everybody agrees, that's easy, that didn't happen. And non-consent wells are the ones that involve reasonable development or drainage. And in those non-consent well situation, there is a balloting process. And that's the language that Mr. Rohde focused on. And that balloting process gives the drilling party, Talisman, the right to put it to the others and say, do you want to participate? And if you don't, you won't get any production until 200% of your expenses are covered. That is the consequence. But that provision is not an exception to the unanimity requirement. It is only a procedure for balloting if one of the exceptions is met and you have a true non-consent well. Because otherwise, as Judge Wilson appreciated again in that very first temporary restraining order, otherwise, why would you carve out anything? Because if it means what Talisman says it means, and Satterwell's adopted the same construction, so if I'm referring to both. If it means what they say it means, why go through the trouble to X out the Section 7 wells? And why go to the trouble to even explain about the development wells and the drainage wells? You don't need it, because under their construction, every well that's under every new well to be drilled can be a non-consent well by virtue of using the balloting process. And that's not what these words say. That's not at all what they say. They can be harmonized in a way that makes sense. And this notion that we're going to somehow shut down production and that this stymies development. First of all, the Carrizo case that Mr. Rohde pointed to did not, the same argument was used to say that a party had to have grounds to refuse to consent. And they said, well, if you have veto power to refuse to consent, then you're going to stop production. And that's contrary to public policy. That's contrary to the purpose of the agreement, which is to develop wells, et cetera. The Supreme Court said, doesn't matter. If you contracted for the right to refuse your consent, not to give your consent, then you are entitled to exercise that right. And you can't be liable in damages for using that right. And it's something that was contracted for right here as well. Plymouth wanted to protect itself because, again, there was a conflict of interest with Kaiser being the owner and the majority owner and the operator. So as Judge Wilson recognized, the first sentence requires unanimous consent, and the provided, however, exceptions are override the need for consent, but only if necessary for reasonable development or to prevent drainage. The rest of Section 8, the rest all the way down to the end is, as you pointed out, Justice Martinez, it provides for a, quote, this is the judge, fairly routine method of allowing those non-unanimous wells to be drilled under it to be proposed and drilled. So that is what the purpose of the balloting procedure in Section 8 is for. And it has a purpose. And Talisman was not cut off from doing all wells. Talisman could have proposed a reasonably economic well. Again, you've heard the history and I won't go through it again, but you can just look at the emails that we cited to in the papers. Talisman was not listening. They did not want input from any of the working interest owners.
How do you respond to the position taken that there are in the remaining provisions of Section 8, inherent in sections to unanimity, to quote counsel?
Well, the exception that they're talking about is the balloting process, the giving notice, and then a procedure for if someone goes non-consent is how it's referred to in the industry. And what they're saying is that means that any well can be proposed and go through the balloting process. It basically overrides and eviscerates the requirement that no well shall be drilled without consent. It makes no sense. They refer to sections 11 and 12 and say, well, look, here's a similar provision, and yet you can override it because there's a process for overriding it. That's not true. That's not true. Section 11 deals with abandonment of wells. And under Section 11, you cannot abandon wells without the consent of all parties. If there is not consent, the party that wants to go forward or does not want to, wants to surrender wants to abandon, can sell out their interests to the other parties, but there will not be an abandonment of that well unless all parties consent. It's just providing what happens as between the parties if there's no consent, but there's still a unanimity requirement. Section 12, similar thing with surrendering of leases. You can sell out if you don't want to consent. But if you do want to go forward and you want to be out, you can sell out. But the event that requires unanimity is not going to happen under the contract unless all parties agree. So they were very deliberate in how they thought about and constructed the allocation of risks and burdens here. And I think it's important to give credence to that. And properly understood, the unanimity requirement is consistent with reasonable development because it allows the minority working interest owners to say no if they believe that it's not a viable well and they don't want to drill it. Again, Talisman could have gone and drilled 2 miles away. They wouldn't have needed consent. Talisman could have tried to show that this well was necessary for reasonable development or was necessary to protect against drainage. Didn't try to do that. It just said, I want to drill this well. And it's interesting because all the wells are clustered in the same area of this huge acreage. And OGE and Matrix repeatedly raised concerns about going forward. This was not just we want to get paid more, or we want to hold out, we want to veto. This was this was the reason why you have to read the unanimity requirement to apply in the words that the court used. I want to say briefly in my time, a lot of time was spent on the 1956 AAPL model form, has absolutely no application in this case. This was not an AAPL form. They don't even try to suggest that it was. We don't even know if this form was used among the 17 that were considered to come up with a model form, but that's not the agreement of these parties, and that form has no bearing on what they intended. It's clear and unobscure from this contract, and that's what the court needs to pay attention to. If there were any doubt, we cited a 1954 Texas Law Review article that said that people in the oil patch were doing exactly these kinds of agreements. It was all over the map. This was our species of the agreement. I want to say briefly, because I'm running out of time, about the standing issue, because it's really interesting that Statoil spends a lot of time on these arguments when it has absolutely no standing. These declarations apply to an operator. There was only one operator the entire time, and that was Talisman. They may have subcontracted out with Statoil, but none of the other working interest owners agreed to that or assented to it in any way. Statoil has no standing to seek these declarations. And if there were any doubt, its interests have become moot because it's sold out, as we've demonstrated in our motions to dismiss. If the court has no further questions, thank you.
May it please the court, Stephanie Kenyart presenting rebuttal for Repsol. And I would like for us to turn back to the missing volumes question today. Humble oil does not apply in this case. Humble oil was a case in which extraneous gas was pumped into a reservoir to save it from encroachment from salt water.
I'm
But-
going to interrupt you real quick.
Yes, Your Honor.
Has Repsol ending last, or you, because I have Stat Oil now and not Repsol, but if you change, that's,
We had, is that all right, Your Honor?
well, having given notice now, yes, sure.
My apologies. I thought that was what the schedule said. On Humble Oil, in Humble Oil, there was no measurement of the native gas in which the royalty owners had an interest before Humble Oil, in an attempt to preserve the reservoir, pumped in extraneous gas. That is what created a commingling problem there. That is distinct from this case. And the Texoga amicus brief submitted to this court explains it very succinctly. We will stand on that explanation. But in short, in a case like this one, where it is undisputed every well was metered, and the dispute over the accuracy of the meters that Matrix's counsel alluded to was not only resolved in 8 months, was over only 2 wells, but Matrix successfully calculated damages off of that because it was able to see the amounts that ought to have gone through the meters. That is how it obtained damages on question 1B9. This is not a case where Humble Oil applies. There is metering, and that knocks Humble Oil out. But you also do not need to resolve the question of Humble Oil, because the reason Humble Oil is brought up is that plaintiffs do not want to be saddled with the burden of proof on this missing volumes question. But the burden of proof was never shifted in the charge. And under Austenberg, the jury charge is the law that governs the case. There is no objection to the burden having been placed on the plaintiffs. And the question that was repeated all 5 times that this issue came before the jury and that it answered identically each time was the plaintiff's net revenue interest percentage share of the net revenues from the missing volumes of production reported as being sold through the CDP. Now, Madam Chief Justice, you asked about the calculations and how numbers were obtained. And the confusion about how $67 million was brought to bear on missing volumes is understandable. And that's because of tab J. The evidence that the plaintiffs provided, they told the jury repeatedly, as you will see from our excerpts of testimony, that they were providing evidence to answer this question about missing volumes. The missing volumes were about what volumes ought to have been reported on Hinkle and Reed in 2013 and 2014, 2 leases for 2 years. But the damages model that led to $67 million for one party and $11 million to the other collects everything that ever went through the CDP for 5 leases from 2012 to 2017. The reason the 2 parties in their appellees briefs give you 2 entirely different explanations for how on earth they reached this damages model is because Matrix is defending a missing volumes argument to try and match the question, while OGE is attempting to defend a commingling argument because that is the only defense to PX 1295. But the other reason a burden shift is necessary in this case is because there's no evidence of missing volumes. Justice Watkins, I think you asked the key question, which was, good thieves leave no fingerprints. And what I think this shows is that here, the jury did not have anything to base the answer on the missing volumes questions to, because it had no evidence that any production was ever taken from the Cook Ranch and placed on the Hinkle and Reed leases. Now, when Matrix was asked to defend this argument, it said there were accounting and allocation shenanigans, and that is good enough. But all of the accounting and allocation disputes, they received awards from the jury. This is a different question. This is a question about whether or not production was taken from one lease and assigned to another, and lies were given to the RRC.
But wasn't the jury entitled to resolve the problems with the broken meters? All of the evidence that's disclosed in the internal emails, weren't they able to take that and use that information against your clients to fill in the gaps that are left by, for instance, the broken meters?
There are 2 problems with that. The first one is that there is nothing but speculation. The evidence that they heard that actually went to missing volumes was David Reeves saying, these RRC amendments are terribly odd. And in response, Ms. Bugamelli tried to give an answer for what had happened. And Justice Scialpa, you asked, what can you tell us about why this happened? Well, the answer in the record is perhaps unsatisfactory. We have given our explanation. We have attempted to provide the state comptroller records to explain what happened with all of this reporting. But ultimately, that fight is irrelevant. Whether or not reporting records to the commission were relevant, were proper, were right, were amended at all times, all that a jury, a reasonable and fair-minded jury can find from that is that something was wrong with the records. But to jump from those recording problems to, and therefore production was stolen, that requires an enormous speculative leap. That is why you wanted to know the answer of what happened with the reporting, because it leaves a question, but it does not make it more likely that there was theft than that there were accounting problems that were pervasive and for which Matrix and OGE were able to recover. But the second issue leads us to non-disclosure. Good thieves leave no fingerprints. What that made me think was my concern with this case, which is, wouldn't you expect a defendant accused of theft to just show beyond a burden of doubt, regardless of whether or not the burden was on them, that they did not steal? But that is impossible when that party has absolutely no idea that the claim is coming. And that was an aberration that we hope this court will resolve. The non-disclosure in this case is unquestionable. At trial, David Reeves said that he didn't even begin reviewing these RRC records that led to the discovery until the summer. In the summer, the parties provided their disclosures. OGE provided its final petition. On June 29th, Mr. Reeves was deposed again, and he stated, after going through his expert report that said nothing about missing volumes and nothing about $79 million, that he would have no other claims to testify about. 2 months passed and trial began. In between, Matrix provided a petition. It states that 4 comments from those petition gave fair notice. 2 of them are excerpts from 2 sentences that are about allocation methodology. One of them is the word disgorgement. And the 4th one is also entirely unrelated to this claim. The new petition was filed. 1 month after that, trial began. In their opening, Matrix and OG said nothing about this claim that dwarfed every other claim. Matrix's excuse before this court is that it wasn't until a comment was made by Repsol's counsel about the size of the pie that they decided to bring the $79 million. But they still did not tell anybody that this claim existed. The trial went on for 2.5 weeks. All of their experts went up and cross-referenced David Reeves, basing their calculations on his information. But David Reeves was not put up to testify until the day before they planned to close. He was the penultimate witness, and that is when the claim was first revealed. There were objections. Initially, the testimony by David Reeves was on pre-admitted exhibits, and that testimony was allowed to go on. And then when he attempted to admit PX 1295 and stated the $68 million claim, there was an immediate objection, which is on 14 RR 306. The court immediately recessed to chambers. There were lengthy arguments. Trial counsel gave every objection that we have repeated on this appeal. Everyone was made. And although G has stated that the objection had to be continued and repeated, that is not the case. Under Rule 103B, when an objection is made and overruled in chambers, it does not need to be raised again to be preserved. And the case further.
Counsel, what was the exact objection that you are representing was made repeatedly?
So immediately, trial counsel, the question was asked to Mr. Reeves what the revenue loss was. And he said, to the Matrix interest, $68 million. And trial counsel went on to request to admit the exhibit showing that, PX 1295. Immediately, the objection was made by trial counsel stating this is for a claim that was not disclosed or that was not disclosed to us. Once that happened, the trial—
disclosed, do you mean pled?
Not pled or disclosed, correct. And then when the parties went into chambers, because the court immediately stopped the testimony, and all of this happens from 14 RR 307 to 15 RR 16. They stated it's a claim for damages, not pled or designated. It was never in reports or disclosures. Mr. Reeves disclaimed everything outside of his report. The damages are seeking a piece of everything in the CDP, not just 2 years from Hinkle and Reed. And further, counsel made it clear they were unprepared for this claim. And the question of where were the fingerprints, with warning, there is a great deal that Repsol would have done. There would have been records. There would have been information about the Hinkle and Reed leases. But they had no notice that this was coming and that this required defense. And particularly extraordinary in an undisclosed claim is for the plaintiffs, which is what they said during the objection process, now say, you lose because you didn't know to have an expert in advance for this claim that nobody told you was coming. That is extraordinary. And in the context of an unpleaded and undisclosed claim, without disclosure, exclusion of evidence is mandatory. The evidence is out. This cannot be affirmed. It must be rendered in favor of Repsol. But furthermore, when there is no trial by consent, there must be clear, undoubted proof that the parties agreed to try the issue. And repeatedly, the Texas Supreme Court in Boz v. Smith in 2018, this court in Montoya v. Gutierrez in 2019 have said, even in an instance where evidence came in without objection, that does not make trial by consent. If there was any objection at any time to an unpled, undisclosed issue, you cannot allow the trial to go forward, and you cannot affirm an $80 million verdict on a claim that the parties had no knowledge they would need to defend. I see my time is out. If there are any other questions that I can answer.
Thank you, Counselor.
Thank you.
May it please the court, I want to thank you all for allowing me to come in person. This is my mental health day. It's one of the first times I've been in a live courtroom since this virus started. Now, the argument that my opponents are making, and I'm here on behalf of Statoil, is that if this honorable panel and myself all drove to lunch right now, and we all took our cars and parked at the valet and gave the valet our keys, that they could come out after the lunch and say, Justice Martinez, you can't drive your car because I've got the keys. Now, let me tell you why I say that. This JOA has to be viewed in context for what it is. The title to the assets is not the JOA. We own the rights to drill and develop our minerals that we leased, whether we had the JOA or not. Because remember, we're just tenants in common out there. If this JOA poofs and goes away, we would have the right to go drill and develop our minerals, sell them, and only account to you for your percentage, right? But instead, beginning back in 1954, when Mr. Rohde was fresh out of law school, we started doing the JOAs. What they are is joint operating agreements, because all these people that own these mineral interests all say, let's put our assets together to work. Now, what they want to believe is they have a superior right to veto the ability for me to get my minerals. Not true. From 1954, when the Kaiser and Plymouth Oil Company signed this JOA, until today, it always had the ability to say, if you don't want to play, you don't want to consent, that's okay. We get a penalty. Now, how does that matter to where we are? Let me first deal with a couple of issues. They've raised Statoil's standing here, and I'm going to tell you why that dies a quick death. In the file is section 1.1 on the assignment of assets, and there is a definition that says, quote, excluded assets, defined term. Excluded assets means any rights or claims of Assignor, that's Statoil, to the extent attributable to the ownership, use, maintenance, or operation of the assets that are prior to the effective time. That's what is at issue in this court, prior to the effective time. But wait, there's more, which is it also excluded, quote, all rights, claims, causes of action of Assignors arising with respect to the Matrix 1 case, defined as this lawsuit. There is no question that we have standing to be here. Now, let me explain why that standing is so important, and why this ruling of this court is so important to my clients. We spent $13 million to drill the first 3 wells, and that's in the jury's answers. What was the reasonable value of the wells? What was the reasonable cost? Well, we spent another $40 million drilling 9 more wells. How does this court's ruling matter? Well, this non-consent provision that I have the most respect for Judge Wilson of anybody. He's a great judge, but he got this one wrong. That non-consent decision really matters because we spent $53 million. Statoil spent $53 million drilling these wells, which by the way, were successful. But we are entitled to be paid because these other owners of minerals didn't pay anything for the drilling of the wells. We took all the risk. We drilled the wells. We successfully put them online. We're entitled to be paid. Now, are we entitled to be paid 1 time, even though we took all the risk? Well, in the oil patch, we have non-consent and they call them penalties because that's what they are. If we're going to go out and spend $53 million and you're not going to pay any of it, and we got to finance it, drill it, risk it, connect it, produce it, report it, we get a 200% penalty under this JOA, and that is right and fair. Let me deal with another issue which hasn't been discussed, but it's replete through all the briefing, which is the CDP, because it has been overlooked in the argument today, but it is really important to my client because we recovered from this jury our CDP fees. They arose at a very interesting time in this case, which was March 26th of, I believe, I'm going to get the year wrong. It's either 2016 or 2017. The people at this side tried to get a restraining order to enjoin my client on a mandatory basis from preventing them from going through the CDP. They wanted to take their product in kind. We'd said you can get it at the wellhead, but you can't come through our separately owned CDP. They filed a request for a temporary injunction. And in fact, in their request for the temporary injunction, they said they would provisionally pay the proportionate share of the operating expenses associated with the CDP. And they even plead that those expenses they would pay 53 cents per barrel of condensate and 18 cents per MCF of gas. We showed up at the temporary injunction hearing and the parties entered into a Rule 11 agreement, which is in the record. And I'm embarrassed that my handwriting is this bad, but it is what it is. But the most important part of this is it says the parties agree that these interim rates shall be applicable until the entry of the final judgment in the trial court. And then when you're holding it straight up and down, you turn it to the side and you find out what that star says. And the star says, Statoil, my client, may demand full rates for the transport and processing through the gathering system at trial. We may demand full rates because what they wanted was very cheap transportation through a CDP that was not owned by the joint interest. And by the way, that's been litigated and lost by them in summary judgment. But they wanted to come through cheaply. And we said, I tell you what, to avoid an injunction, because that's the top word of this in my handwriting, in lieu of an injunction, the parties agree to all this. You're going to come through cheaply. We're going to go to the courthouse and we are going to have at the trial a question is what the rates are. Now, nobody rejected their agreement under this Rule 11 agreement. And so this isn't a complicated breach of contract question like you would have if the parties had rejected. In fact, the cases are replete, and I'll cite the court to Federal Lanes, which is 905 Southwest 2nd, 686, and Caballero, which is 411 Southwest 3rd, 562. All those cases say it is ministerial for the court to enforce the Rule 11 agreement if the parties have not withdrawn their acceptance by the time of the judgment. So let's get to this Exhibit 38, which did not get admitted to the jury because in Volume 2 at page 33, lines 12 through 15, Judge Wilson captured the essence of what this was. He said, It looks like Statoil very clearly said, we want to be able to get the whole amount because we were offering this in a pretrial to be admitted, but they said it's not coming in. And by the way, Mr. Zukowski, who's in the courtroom for OGE, says at page 35, lines 3 through 7, if the court is simply going to submit an issue for the jury to determine what is a fair and reasonable rate is, and then later there's going to be a declaration in that regard, quote, I can live with that. That's from the record. So guess what we did in this trial? We got to the jury charge. Judge Wilson said, we are going to submit to the jury what's a reasonable rate. And by the way, we said what the reasonable rate was the same rate that was in their application for a temporary injunction. They argued a much lower number. The jury came back. They gave us exactly what we asked for oil. And they cut us by 30 cents for gas. That's what happened. That's the jury charge. And then Judge Wilson, as the law requires him to do, ministerially applied that. So we recovered that judgment. So sitting here today, this CDP and these fees are very important to my client. And the context of this litigation has an even greater impact, which is, remember, we only were talking about 3 wells when we went to the jury with this case in the summer of, I believe, 17. We drilled 9 more after that. We couldn't sue for that in that trial because we had not yet incurred those well expenses. But these parties are all in another lawsuit now, down in Cotulla, Texas, LaSalle County. And that lawsuit is going to be particularly informed by this court's ruling. Thank you so much for allowing me to come live before this panel. And that concludes my argument unless y'all have a question for me. Thank you.
Nothing further. Thank you. That appears to conclude argument. This case is submitted and under the court's consideration and an opinion forthcoming. Have a good day.
All rise.